It's my pleasure to be in your midst this afternoon. Right Honorable Dr. Noheem the longest serving speaker in Lagos today, the longest serving legislator in Lagos today, the award-winning speaker, not only in Lagos, not only in Nigeria, but all over the world. And ably represented by our own personal person, the finest in our midst, very young, intelligent, intellectual sagacity, honorable who are representing as speaker. Thank you very much. The chairman of Judiciary Committee, my brother, you are doing wonderfully well. In fact, if I could count your public hearing that you have done this session alone, in fact, I give it to you. Kudos to you. We appreciate you. You are doing well. And you are contributing a lot. Thank you very much. And to my distinguished honorable members here present, I want to thank you very, very much for the unity in this House of Assembly. I also thank you very much for the support to Right Honorable Dr. Noheem. I want to say you are doing very, very well. This is not one of our established protocol. It gives me great pleasure to present this bill that is sponsored by Robert and seasoned lawmaker, Right Honorable Dr. Noheem, the Speaker of the Lagos State House of Assembly, that is above the common standards of excellence. This bill cannot come at a better time. It is coming at a period of great need to overhaul our correctional services and centers in the state. As already said by the chairman of this noble committee, Honorable Olayinka, the correctional services have been devolved from the exclusive legislative list to the concurrent legislative list by the 5th alteration of the 1999 Constitution of the Federal Republic of Nigeria, thus enabling us to correct all the anomalies existing in the correctional system by the federal government. The Lagos State Correctional Services Bill 2025 is very important for Lagos State. This bill protects human rights, follows international standards, and sets up a proper structure for both the officers and the people in custody. This bill has 68 clauses and the provisions as follows. Clause 1 of the bill defines key words used in the bill, such as custodial service, non-custodial measures, and affective nature. These definitions help everyone understand the bill clearly and avoid. It will have two arms, namely custodial and non-custodial. This bill also talks about training institutions for staff. The Controller General's role and other key positions are clearly described. In clauses 6 to 11, a governing board is created, made up of people from government, the courts, and civil society. This helps balance power and ensures fairness. This bill also explains the process for appointing and removing members. Clauses 12 to 17 of the bill cover funding and how the service will be run. Experts can be brought in when needed, and rules for openness and honesty are clearly stated. Clause 18 of the bill creates the Office of the State Controller General. This is the Chief Executive and Accounting Officer for Correctional Services in the state. This bill states the person must be qualified, having not less than 15 years vast experience in correctional management and administration, and must present a yearly plan to show what the service is doing. Clause 19 of the bill mandates the service to have a legal advisor. This is important because correctional work often involves legal matters. Clause 20 of the bill gives correctional officers the entitlement to pensions just like other public workers. Clauses 21 to 22 of the bill elaborates on the classification and functions of the custodial service. The clause lists the different types of correctional centers that will be created, some for men, some for women, and others for juveniles. This follows best practices worldwide. Clauses 23 to 27 of the bill deals with custody, overcrowding, and detaining management. To prevent overcrowding, the Controller General must alert the government within 7 days if a center is full. If nothing is done after 3 months, new inmates can be refused. This bill also encourages working with courts to avoid unnecessary delays. Clauses 28 to 29 of the bill address non-custodial services. These clauses explain how non-custodial punishment will work. Committees will be set up to manage these services and involve the community in correctional efforts. Clauses 30 to 34 of the bill contain non-custodial modalities. The clauses give room for probation, community service, and restorative justice. These are modern ways to correct the behavior of deviants without having them locked up. Clause 35 of the bill establishes training institutions. It provides that inmates will have access to farming, education, and vocational training. The income from their work can be shared, which helps with their welfare and makes the system more sustainable. Clauses 36 to 37 of the bill deals with treatment and labor of those in custody. These clauses prohibit torture or forced work. Any work must be done under good conditions, and people with health problems must be excused.